Okay, good afternoon. This is Lauren Brier. I'm a partner within the Government Contracts Practice Group at PilieroMazza. And I'm here with my colleague, John Neri, who's an associate at the firm who focuses on construction and litigation and dispute resolution. And we appreciate you guys joining us this afternoon. We're going to be talking through an annual review of certain decisions that came out from the Board of Contract Appeals, particularly the Civilian Board of Contract Appeals and the Armed Services of Contract Appeals, and then some statistics that have come out from their annual report summaries. So just to give everyone some background on myself, I am the practice chair of the REAs Claims and Appeals Group within our Government Contracts Practice Group. So I mostly focus my practice on requests for equitable adjustment, when we have small business, mid-business, large businesses reaching out as it relates to really any type of dispute or contract interpretation issue, that flows through me within the firm. And I also assist with suspension and debarment matters, FCA actions, and really any other issues under the FAR and CDA. I'll turn it over to John to give a little bit of background on his practice.
Yeah, thanks, Lauren. I'm John Neri. I'm somewhat new to the firm. I'm an associate here at PilieroMazza. My background is in construction litigation, which I had practiced for about 3 years. And I still do a little construction litigation here, but have definitely moved into a lot of other sorts of contract claims in the government universe. So I've been, happy to work with Lauren on some government claims recently, and I'm happy to help her present today.
Thanks, John. We appreciate it. Just to give a little bit of background on PilieroMazza, we are a business law firm that focuses on assisting federal contractors. Beyond our REAs Claims and Appeals Practice Group, we also do a lot of bid protest work. We also do a lot of mergers and acquisitions, assisting with JV agreements, small business issues, IP and technology rights, and we also have labor and employment division and then litigation division that assists us mostly with prime and subcontractor disputes. Getting into the agenda that we're going to cover today. So we're first going to start with talking about the annual report summary that came out of the Civilian Board of Contract Appeals, and they obviously oversee all civilian related contracts and related disputes. And then we're going to talk about the same type of report summary that came out of the Armed Services Board, just to give some insight as to how things have been proceeding over the last year. Then we're going to talk about the NDAA and really what's come out of that and its impact on contractors in the federal government. And then we're going to really focus in on some big cases that came out from 2023. The topics here are waiver of the government's right to terminate. We're going to talk about the CDA subcertain requirement and it not being a jurisdictional issue at the board. We're also going to be talking about some issues that contractors should be aware of as it relates to discussions in the evaluation and protest process. Reasonably expected outcomes in the contract. We're also going to be talking about cure notices and those types of requirements that the agency has to follow. And then finally, we're going to talk about a pretty anomalous case about the awarding of lost profits for expectancy damages, which doesn't happen very often at the Board of Contract Appeals. So we'll get into that a little bit, and it's going to be provide some good practice points for moving forward over the next year. So focusing first on the CBCA and the annual report summary. So every year they provide a good list of statistics that drives our analysis as to how we can assist our contractors and clients moving forward. So first, the CBCA docketed 247 new CDA appeals in fiscal year 2023. That was a pretty big surprise to us. I mean, that's a 40% increase from last year. I think personally, a lot of that may be driven from COVID-19 impacts that are still trickling in, and then as well as inflationary impacts, people dealing with supply chain disruptions, material increases that often drives disputes. So there was a significant jump in appeals filed with the CBCA this year. The CBCA resolved 185 CBA appeals in fiscal year 2023. Not a huge shock as it compares to 194 that they resolved last year. That's pretty consistent. I think the big takeaway from the two comparisons of these bullets, right? We have a 40% increase in appeals being docketed, yet resolution of those appeals, the number remains stagnant. So something like that, I would tell our clients, if we are filing an appeal at the CBCA, it's likely that it's going to take a little while. I mean, I've been saying that for a few years, but I think things are taking even longer to get decisions, not just final decisions, but also decisions in motion practice. So if we're filing a motion for summary judgment, decisions on those used to take around 3 to 6 months, and now they're taking closer 6 to 12 months. I do think the CBCA docket is overloaded, and I think the amount of resolutions this year as compared to the amount of filings really speaks to that. We're also seeing 25% of the appeals resolved in fiscal year 2023 were on the merits. That's a 3% increase from fiscal year 2022. I mean, that's a good outcome for contractors that are looking to get resolution and resolution on the facts, not just procedural issues. So that bodes well for contractors moving forward, that more decisions are being made on the actual factual issues, not just like, hey, you filed this claim late, therefore we're going to knock you out or dismiss the case. The CBCA ruled in favor of the contractor in 45% of appeals that were resolved by a decision on the merits. So that's a very great statistic. It's a 24% increase from fiscal year 2022. And really what that shows is that the CBCA is siding with the contractors over the agency in a lot more of these cases. So there's more of a willingness to rule on the merits, and then there's also more of a willingness to hear the contractor out. So all good things if you're dealing with a dispute on a civilian-based contract. These statistics bode well for contractors. The CBCA ADR program fully resolved 30 cases in fiscal year 2023. This is also a very solid statistic for contractors, but there is a 5% increase. One of the big practice points that I try to tell my clients is when we get into a dispute, particularly my small business clients, is that the ADR program is there to our benefit. It allows you to resolve certain issues in short order versus having to go through a lengthy appeal process where you're engaging in discovery and you're engaging in motion practice and then you're going through a full hearing. If you are able to access the ADR program with agency counsel's agreement, the ADR program bodes well for resolution and not incurring significant legal fees and time in trying to resolve certain disputes. So the fact that the CBCA ADR program is being utilized and it's increasing the use of that, that's all a very good sign for contractors, particularly small businesses. So we can move to the ASPCA annual report summary. It's a little bit different. So the ASPCA, they docketed 342 new cases in fiscal year 2023. That was a 14.5% decrease from last year. I think a good amount of that, I'm hopeful, is that issues are being more readily resolved with the armed services agencies, particularly the Army and the Navy, where there's more of a willingness to negotiate on the front end without having to reach the level of an appeal with the Armed Services Board. But there has been a decrease in docketed cases, and that may speak to more of a willingness for the DoD-based agencies to try to resolve these before they get too far through the appeal process. 24% of all cases resolved in 2023 resulted in a merits decision favorable to contractors. Honestly, that's more of a consistent rate that we see. 45% of the civilian agencies, it's a great sign. But I will say that it's harder to be successful at the Armed Services Board, and this percentage does kind of speak to that. There are 189 suspended cases at the end of fiscal year 2023. That's a 3.4% increase from fiscal year 2022. That big driver, I actually am kind of seeing this in my practice, and I think that this may play into it, is that for a lot of military-based construction disputes, there's a sudden willingness from agency attorneys to suspend the case until the project is complete. So if you find yourself in a dispute over, a minute issue or a specific schedule concern, a lot of times we'll file the claim, and then the agency attorney will file the claim, will appeal it, and then the agency attorney will step in and say, well, hey, let's suspend this case. Let's wait till the project is fully complete so we know where everything sits at closeout. If there's liquidated damages we need to talk about. And it's to achieve a more global settlement. And oftentimes it's beneficial to the contractor as well. So I think we're seeing this a lot more often in our construction cases. And I think that may be one of the drivers for why some of these cases, more cases are being suspended. Another driver is false claims investigation. So if you have a false claim investigation running tandem to an appeal at the Armed Services Board, the case is almost always going to get suspended to allow that FCA investigation to run its course. The Armed Services Board is unlikely to rule on a case and say, hey, government, you owe this contractor money, while simultaneously from that, DOJ is investigating that same contractor for potential costs owed back to the government. So that's one of the major drivers of suspending a case at the Armed Services Board as well, is that if there's an FCA investigation running tandem to that appeal, that often will result in a suspension. And at the Armed Services Board, the ADR program fully resolved 69 cases in fiscal year 2023. That's a 5.7% decrease from fiscal year 2022. I think that, and this is also just a practical point that I see, is that a lot of the civilian-based attorneys in the Office of General Counsel, there's more of a willingness to operate through ADR versus going through the full litigation process at the board. I see less of a willingness with armed services attorneys. I'm not entirely sure of the reason for that, but one of the reasons I am seeing is that a lot of times armed services attorneys like to go through the discovery process first before they're open to consideration of ADR. That's also very similar to how DOJ operates on appeals at the Court of Federal Claims. They're very unlikely to engage in mediation or settlement until the discovery process has run its course. And I think that the Armed Services Board and the Armed Services attorneys are becoming more inclined to go through discovery before they even want to consider going through the ADR program, which is a little bit different than when you're dealing with a civilian agency. So I will turn it over to John and let him talk through some changes of the NDAA.
Yeah, the National Defense Authorization Act for fiscal year 2024. Each year, as you may know, the NDAA authorizes funding levels and provides authorities in the U.S. military and other critical defense priorities. This year, in 2024, the 2024 NDAA was signed in December 2022, 2023. And while I'm obviously not going to go over all the changes made in this year's rendition, I'll point to a few changes that I think are particularly worth noting. And I'll try to add some substance where I think it's appropriate. I'll start with provisions that focus on the government's preference for domestic goods. Section 804 prohibits the DoD from entering into a contract with any fossil fuel company that operates in the Russian Federation or is more than 50% owned by an authority of the Russian Federation government. Section 812 prohibits the DoD from contracting for consulting services with any entity that does business with the Chinese or Russian governments, as well as state sponsors of terrorism and certain other sanctioned entities. These two I think are pretty straightforward. Section 825 prohibits DoD from obtaining logistics platforms from People's Republic of China or its state affiliate entities. And then Section 835 increases domestic content requirements for major defense acquisition programs. For this one specifically, it increased the requirements for component parts of certain end products to qualify under the Buy American Act. So what that means is, well, the U.S. produced component parts needed, U.S. produced component parts needed to exceed 60% of the cost of all component parts of an end product item in order for that item to be qualified under the Buy American Act last year in 2023. That percentage has now increased to 65% for items delivered in this year through, and that's going to extend through 2028. And that will again increase to 75% in 2029. So again, that's the component parts, the percentage cost of proponent parts to qualify under the Buy American Act. As for new prohibitions on contracting with certain foreign entities, this year's NDA enacts the American Security Drone Act of 2023, which prohibits agencies from procuring unmanned aircraft systems manufactured or assembled by covered foreign entities. These foreign entities are related and controlled by China. However, a list of covered foreign entities will continue to be developed and published on sam.gov. All right. Section 318 prohibits DoD from requiring non-traditional defense contractors, that's contractors that have not contracted with the DoD over the past year, to disclose greenhouse gas inventories or emissions as a condition of award. Traditional defense contractors, these are those who currently hold a DoD contract or have held a DoD contract within the past year, are not required to disclose greenhouse gas inventory or emissions as a condition to award until December 22nd, 2024. Section 824 extends DoD's authority to modify contracts to make economic price adjustments to address inflation. I will say it's worth noting that contractors' claims under this section have been denied. Our firm knows that they've been denied for reason that funds have yet to be allocated towards covering claims for inflation. So basically the fact that the contracting officers technically have authority to issue EPAs for inflation seems to thus far be inconsequential without allocation of funding. All right, a few provisions aimed to assist small business contractors. Section 862 reduces the time period after which a contractor must notify a contracting officer that is past due on paying a subcontractor. This went from 90 days to 30 days. This is of course aimed to ensure subs are being paid in a timely manner. Notably, Section 862 also authorizes but does not require that COs can downgrade the prime contractor's past performance rating in cases of unjustified failure to pay a subcontractor. It also further requires contractors to cooperate with contracting officers in instances where the contracting officer has found unjustified non-payment to ensure full payment is made to the subcontractor. So this obviously section is aimed to protect subcontractors and make sure they're being paid in a timely manner, and kind of increases the restrictions and penalties on contractors that the reporting requirements they have to the government, in hopes that it will get subcontractors paid more quickly. Section 863 increases the goal for participating in federal contracts by service-disabled veterans-owned small businesses from 3% to 5%. It's pretty straightforward. Section 865 requires the Secretary of Defense to amend DFARS 215.305 to require the DoD agencies to consider the past performance information of affiliate companies, if relevant, when small businesses bid on DoD contracts. And I guess that depending on the small business, this could be seen as good or bad. Slide 14. Okay, we're gonna move on. We're moving away from the NDAA and into some key decisions in 2023. I'll start with the Civilian Board of Contract Appeals decision in Hughes Group versus Department of Veterans Affairs. And brief summary, in November 2015, the VA awarded a contract to the janitorial services to Hughes Group. During contract performance, both parties voiced complaints. The agency, of course, believed Hughes was not providing the level of service required under the contract. While Hughes complained that the VA was slow to repair government furnished equipment that was critical to its performance. Despite early performance issues, the VA exercised an option year on the contract. Regardless of the execution of the option year, the VA eventually issued a cure notice and stopped paying Hughes for its services for a time, only to ultimately terminate the contract for cause. It terminated the contract for cause after paying Hughes its overdue invoices. Appealed the VA's decision to terminate, and the board recognized that while the government may terminate a contract for cause where justified, it can also waive its right to terminate through its actions or statements indicating its preference that the contractor continue performance. In this case, the board found that the VA's exercise of an option year, as well as the fact that it waited until the end of the contract period of performance to terminate Hughes, while simultaneously directing Hughes to continue performance, were sufficient actions and statements to establish that the VA effectively waived its right to terminate for cause. The board therefore converted the termination to one of convenience. All right, we're going to stick to the same theme here.
So John, let me step in just really quick on Hughes.
Okay.
So Hughes is a really good practice point for a lot of our clients and just contractors in general. And it really speaks to solid record keeping as you're corresponding and interacting with the government. And one way to demonstrate a waiver is through statements that speak the opposite. So one thing Hughes was able to do here was that they had a lot of written communication with the contracting officer and those on the ground, basically showing like directives to continue work and really no indication that they were doing a bad job or that, you know, suddenly their contract was going to get terminated for default. So the big takeaway from this case, at least for me to my clients, is that when you're interacting with boots on the ground, always make sure that you're including the contracting officer. They are the ones with ultimate and actual authority to make changes to the contract or to provide ultimate directives. So make sure you're communicating with the contracting officer as much as you can, and that you're getting things in writing versus verbal calls. So, you know, if these conversations between Hughes and boots on the ground on the agency side were just verbal, I mean, it makes the argument much easier for the agency on the side that, hey, we exercise the termination for a default, this is the right thing to do. Versus, hey, we have, you know, 10 emails where the government, particularly the CEO, is directing us to continue work. There's no indication of a termination for a default here. So again, very important to make sure that you're doing things in writing and that you're keeping a really solid record of what's being performed, what's being done, who you're interacting with. Because, I mean, I'm not saying that, you know, you always want to operate like you're going to eventually be in a dispute with the government, but it's just good business practice to make sure that things are in writing, things are being relayed to the CEO. By the chance that you find yourself in a dispute, you then have this really solid record to use to your advantage on appeal. So that's another big practice takeaway from Hughes.
All right, looking to BES Design Build LLC versus the Department of Veteran Affairs. This notably was decided by the CVCA just a month after Hughes. In September 2015, BES entered into a construction contract with the VA for a renovation project. There is, of course, discrepancies between the contract specifications and the conditions of the existing building that BES was working on. And the VA issued multiple modifications and REAs over the course of the project. And however, despite the modifications and the fact that the VA extended the completion deadline for the project, further delay occurred, and the VA eventually terminated the contract for default. BES ultimately filed an appeal with the board on which it challenged the VA's termination. BES specifically argued that the contracting officer had waived the extended deadline for the project completion by allowing the contractor to continue work on the project for 5 months beyond the completion date. So even though the contract had been extended through modification, they surpassed that extension date, continued to perform, and the government, BES is alleging that the government allowed them to perform for up to 5 months before it was terminated. While the board recognized that the government can effectively waive the contract completion deadline through non-enforcement, in the case of construction projects, waiver typically occurs only in unusual circumstances where unreasonable period of time has passed between the established contract completion date and the termination for default, where the government allows the contractor to continue performance without communicating concern or its intention to assess liquidated damages. Notably, the board neglected to define, in this case, what would be considered to be an unreasonable amount of time between the initial date of completion and the termination date. It's likely circumstantial based on the contract and the facts of each case. However, I would venture to guess that in the case of a construction contract, a tribunal is unlikely to find any delay in issuing a termination under a year to be unreasonable. So just something to keep in mind. The board held in this case that because the VA continued to communicate its concerns regarding project delay after the contract deadline had passed and had issued a show cause notice for BES's default, the VA did not waive its right to terminate for default in this situation. All right, some takeaway points from these two cases. It's important for contractors to be mindful during performance that government may waive its rights to terminate for cause through its actions and statements. For this reason and many other reasons, it's important to maintain comprehensive records of all correspondence between the contractor and the government. As Lauren had pointed out, government statements during contract performance may dictate whether the appeal board considers a termination to be justified. As for construction contracts, the government only waives its right to terminate under narrow circumstances. Again, those are where the board determines that an unreasonable period of time has elapsed between the initial end date, completion date of the project to the time it decides to terminate, or where the government allows continued performance without further communicating its concerns to the contractor. And again, as Lauren said, maintaining records and always have contractors should maintain their records and always have the government convey its instructions in writing when possible. I know project managers often meet with CEOs and their representatives in person. To that end, it's important to have them follow up in writing in order to maintain a written record of any affirmative directions that the government's giving project managers on site.
Yeah, that's a good point, John. And stuff like meeting minutes, daily reports, that get submitted, after those meetings. Those are all really beneficial to our clients when we find ourselves in a dispute. Moving to the ECCI case. So this is a big case that came out, and it deals particularly with the some certain requirements as they relate to FAR 52.223-1 and then also the CDA in general. So I'm going to run through the two cases that kind of deal with these issues and then how they're playing out in current board matters. But so in ECCI, the contractor submitted a claim seeking about over $13.5 million for a number of government delays. They ended up filing an appeal at the Armed Services Board based off of a deemed denial. So that means that they issued a claim, the agency sat on it, didn't issue a final decision within 60 days as required under the CDA, and that gives the contractor, it triggers an automatic right for them to appeal a deemed denial. So that was the process that took place here. 3 months after the board hearing concluded, the government filed a motion to dismiss for lack of jurisdiction. And just to give some background on the litigation process at the board, to get to the hearing, unless it's under the accelerated procedure, it can take a year to 2 years to get to the hearing process. So the fact that 3 months after the board hearing took place, the government is now filing a motion to dismiss on a procedural issue. It's just completely unfair to the contractor and the amount of likely legal fees that they expended and time on fighting this dispute. And in that motion, and they argued for the first time that ECCI's claim was improper because it did not state a sum certain for each of its distinct claims. And the ASPC ended up dismissing ECCI's appeals for lack of jurisdiction. The FAR requires a sum certain. So a sum certain is an actual number that you're seeking for recovery. You cannot file a claim, or you shouldn't file a claim with conditional language, like saying, we're filing this claim for about $2 million. You want to have very specific numbers tied to each particular claim. And at least that's what we instruct our clients to do, and we assist with the preparation, or we prepare them ourselves. Just making sure that sum is exact and you have supporting cost information for that purpose. Nevertheless, ASPCA dismissed ECCI's appeals for lack of jurisdiction. They appealed it to the Federal Circuit, and the Federal Circuit recognized that it has historically identified a sum certain requirement as jurisdictional based on the FAR's definition of a claim. Again, FAR 52.223-1 defines a claim and it requires a sum certain, but the CDA does not include that. So recent Supreme Court decisions reflect that rules outside the statutory text, which is the CDA in this case, are not jurisdictional. For a procedural rule to be jurisdictional, the relevant statute must clearly state that it is jurisdictional. Again, the CDA itself does not require a sum certain, the FAR does. So the Federal Circuit overturned the Armed Services Board decision. And the court further held that any defense based only on FAR requirements can be waived if not asserted early in the proceeding. So basically what the Federal Circuit said is that they could have raised this jurisdictional issue. However, it had to have been raised early on in the process. By allowing the case to run its course, go to hearing, and then 3 months after to raise this procedural issue, it was too late, and they waived their right to assert it. So moving to PAE. So in PAE, this is also an Armed Services Board case. So PAE and the Navy disagreed about the allowability of contract costs previously paid to PAE pursuant to the CARES Act. The Navy contracting officer sent PAE a letter titled Demand for Payment for Unallowable COVID Costs. They asked PAE to contact the CO in writing if it disputed the debt. It warned the government's payment office could initiate procedures to offset the debt against other payments owed to PAE. It also noted that PAE could ask to repay the debt in installments or defer payment for good cause, but the demand was not labeled a COFD and it did not include CBA notice of appeal rights. Despite not having these procedural requirements, PAE appealed the demand letter to the Armed Services Board, and the government moved to dismiss the appeal for lack of jurisdiction. The government argued that the letter that they sent, to this demand letter that they sent, did not constitute an appealable final decision. I will say this, I deal with clients all the time getting demands for payment. Sometimes they have CDA notices, sometimes they don't, but I always suggest that those get treated as contracting officer final decisions, because a COFD is equivalent to a government claim. And a government claim is when they're going after you for money. So if you get a demand for payment for unallowable COVID costs, for example, that is a government claim that you have the right to appeal. And the board ruled that same thing, is that basically saying that just because this communication was not labeled as a final decision, the board still had CDA jurisdiction. Absent notice of a contractor's appeal rights is only relevant if it prejudices the contractor. So say you get a demand letter, it doesn't have any notice rights, or hey, you got to appeal this within 90 days or you're going to be too late. The only time that becomes problematic is if it impairs or impacts the contractor's ability to appeal. The agency can't use that to their defense and then say that there's no jurisdiction. So again, the fact that the letter invited PAE to respond to the letter and allowed for a payment plan did not mean the CO failed to make an unequivocal demand or a government claim. Most government claims invite the contractor to respond to the letter, particularly demands for payment. They also say that if you appeal this, you have the right to defer payment. If you get a demand for payment and that language is not in there, I've had clients come to me about that. I always suggest that you reach out to defer the payment, particularly if you have the intention to appeal, because right now it's a dispute. You shouldn't have to pay the government if the issue is in dispute. So I always recommend that they submit a deferral letter, reasons why, and get that out there, even if the demand itself does not say that they can do that. So the key takeaways from really both of these cases is the ECCI decision is really positive for contractors. In the sense that it puts pressure on the agency to get their ducks in a row and understand what procedural arguments they may have, versus waiting for the contractor to incur millions of dollars in legal fees and also years of time to get through the hearing process, and then for them to raise their procedural defect too late in the process. So it does provide some protection for procedural defects for the contractor. The PAE decision, it's a good practical decision for clients to understand what a demand for payment looks like and your rights under it. But it was unfortunately a decision that the Armed Services Board kind of punted on the jurisdictional point of it. They could have brought up a more jurisdictional issue by saying that this is something that should have been addressed early on, but they didn't really get into that. So PAE, in short, does represent a missed opportunity for them to really join in on the ECCI decision, and then also Supreme Court and Federal Circuit, that are really focusing on the distinction between what's jurisdictional under the CDA and what FAR requirements are out there. But you can take away some good practice points from PEAE. If you get a demand for payment, what you need to do is you need to appeal that if you believe that you should not have to pay that amount. And so I will kick it over to John to talk about the Chugich decision.
Yeah. So in Chugich Federal Solutions Incorporated, Chugich was awarded an indefinite delivery, indefinite quality contract with the Navy. During the solicitation, the Navy had provided Chugich with an independent government estimate for the cost of performance based on the incumbent contractor's performance. So they provided an IGE that was based on information provided by the incumbent. The government noted on the IGE that the IGE served as a projection of scope requirements, not a fact to rely on. While the contract was a firm fixed price, the solicitation asked that the offers provide staffing levels in its proposal, meaning that Chugich basically had to indicate the number of full-time employee hours that it would require to perform under the contract. Following submission of its proposal, the Navy entered into discussions with Chugich and recommended its revising of the proposal to make sure it budgeted enough time for unlimited service calls. so enough cost and manpower for unlimited service calls. Despite the fact that the Navy had concerns about Chugach's price proposal, it awarded the contract anyway. Chugach quickly realized upon preparing to perform the contract that it had proposed inadequate staffing levels, and it had to increase its full-time employees, which of course resulted in substantial increases in cost to the contractor. Chugach issued several claims to the Navy, which were appealed to the ASPCA, including claims of negligent negotiations, mutual mistake, constructive change, and breach of good faith and fair dealing. The board dismissed the majority of Chugach's claims, finding that the contractor had failed to produce evidence sufficient to support its theories of negligent negotiations, superior knowledge, mutual mistake, or constructive change. Some takeaways from Chugach. In this case, the board determined that Chugach could not rely on the provided IGE in preparing the pricing, which ultimately led to the dismissal of Chugach's claims. Here, the board found that Chugach was unable to show that the government was unreasonable in preparing the IGE for the mere reason that it relied on the past performance data from the incumbent contractor. In other words, the board held that there needs to be a showing of evidence that the government's reliance on incorrect data or its utilization of an improper statistical evaluation process in preparing and providing its own estimates. It was saying that to the extent that the information that the government was relying on from past performance of the incumbent was adequate or accurate, I should say, then that was an adequate IGE for the purposes of providing it for mere reference, for the purposes of providing it as a guide for Chugach in preparing its proposal. I think another key point, though it's not listed here, is that contractors need to be careful about issues that are flagged in discussions or in Q&As that occur during the proposal phase during pre-award of a contract. Contractors can't rely on agencies to fully recognize and disclose certain risks, maybe risk factors that the government's seeing and that could affect the proposal pricing prior to the award. Lauren, do you want to say anything else about Chugach?
I am not, because we're running a little short on time.
Okay.
And we have a few more cases to go through, but if people have questions about Chugach, just feel free to reach out to John or myself outside of the webinar, and we're happy to answer any questions that you might have.
Okay, we'll move on. Intercon Security System versus Department of Justice. In this case, Intercon was awarded 2 contracts with the U.S. Marshals Service to provide security guards. Because the guards were authorized to carry firearms and make arrests, the contract required that the court security officers to undergo annual medical examinations. Those who failed, under the contract, those who failed or were overdue on their annual medical examinations would not continue to perform contractual duties until they gained the FOH's approval. When I say FOH, I'm saying USMS had the Department of Health and Human Services Federal Occupational Health Agency perform all its medical qualification tests. Thus, the FOH, not the USMS, had final say in determining whether Intercon employees passed their mandatory medical examinations year after year during the term of the contract. During contract performance, FOH disqualified several Intercon employees from continuing to perform their security guard obligations under the contract. Intercon consequently terminated these employees. The terminated employees then sued Intercon under the Americans with Disabilities Act and several state anti-discrimination laws. Intercon settled the lawsuit and submitted a claim to USMS for cost settlement, claiming that the government breached the terms of its contract by deeming physically capable employees as disqualified as well as breaching its implied duty of good faith and fair dealing for subjecting the contractor to discrimination suits. Civilian Board of Contract Appeals ultimately dismissed Intercon's claims, finding that USMS had no contractual duty to review the medical determinations of FOH. The board further found that Intercon's interpretation of the qualification standards conflicted with the plain language of the contract. Specifically, Intercon had asserted that the contract only required the guards to be in good physical condition, whereas the CBCA found that the contract actually contained pages and pages of specific medical standards that informed the FOA's determinations as to the ability of these employees to perform their duties. Lastly, Intercon failed to show USMS breached the implied duty of good faith and fair dealing. While the board agreed with Intercon's argument that implied duties require USMS to act in a manner consistent with the contractor's reasonable expectation, the board further held that performing in the manner consistent with the contract requirements cannot breach a duty. Thus, as USMS, to the extent it had acted consistently with its contract requirements, had no reasonable basis to expect that Intercon would terminate and the medically disqualified employees, and that the lawsuit would then ensue. This decision demonstrates how the CBCA determines what can be reasonably expected after government action based on contract language. I think it also demonstrates how the contract may effectively delegate certain authority across multiple agencies, which I think is something contractors should pay attention to.
Thanks, John. Okay, so I'm going to talk a little bit about cure notices and the requirements that now exist for certain agencies within the civilian board, or that operate with the civilian board. So when Alan Frick, they're a VA contractor that performed cemetery inscription work. They had 2 contracts with the VA, but fell behind due to a delay in supply delivery. The VA issued cure notices requiring assurances of future performance, or threatened to terminate the contractor for default. At the time the notices were issued, the contractor had significantly caught up on its work, and so it didn't respond to the cure notice. The VA then issued a termination for default, pointing to the contractor's failure to provide assurances. So the CBCA reviewed the case and ultimately converted the termination for default to one for convenience, mostly because the cure notice language didn't put the contractor on proper notice that it wanted a fully developed plan forward. And the case really emphasizes the importance of clear cure notices, and that when notices aren't clear, that the contractor has the right to successfully challenge a termination for default. I will say, you know, the biggest plate for me from this case is to remind clients that when they get a cure notice, even if you are in the mode of successful performance, you always need to respond to that cure notice, never let it sit. However, if you do let it sit, there is an argument to be had based off of the Frick case that the cure notice that you were given did not provide proper information as to how to appropriately respond and make sure that the agency is comfortable with your future performance. So although always suggest you respond to a cure notice, never let it sit, never ignore it, if you do find yourself in that position where you didn't respond or you didn't timely respond, that this is a case that you could use to your advantage to argue that, hey, we weren't put on sufficient notice, we weren't given enough detail as to what the agency was looking for. So this case is definitely important, but the biggest takeaway from this case is that if you get a cure notice, respond to it no matter how well you're performing. So we can go to the next slide. So this is Flatland Realty, and this is a big case for those that practice within the government contracting community, mostly because when I have a client that comes to me, they are always asking me about lost profits and how they could potentially recover it, in the sense like, hey, you know, we got a bad CPAR, it got changed to positive CPAR, but we lost 4 projects and I want to go after the government for those lost projects. The Armed Services Board and the Civilian Board hardly ever rule in favor of awarding a contractor lost profit expectancy damages. This case is a little bit different, and the big takeaway here, because we're running short on time, is this case was not applicable to the FAR, and by case I mean the contract. So because the contract didn't have a standard termination for convenience clause, the Armed Services Board treated the dispute as a breach by the government. And instead of being able to just convert it to a termination for convenience, where the contractor has the ability to submit a cost proposal for costs incurred from the up until the termination that were unpaid, and then also wind up costs. In this case, because there was no termination for convenience clause to convert it to, they treated it as a breach. And by treating it as a breach, they awarded expectancy damages, which were the lost profit. So the situation is a little bit different from your most standard federal contract, which almost always apply termination for convenience clauses. But here, because that clause was not in the contract, they were able to argue a breach and they were able to recover lost profit. So really the type of contract is how this is going to play out. And if you find yourself in a contract that you get improperly terminated for default and you have no T4C clause in there, then lost profits may be a possibility. But in your more standard contracts, I would still say that that is a very uphill battle as far as recovery if we find ourselves in a dispute with the federal government. So I will turn it over to John to finish this out.
Amentum Services Incorporated, in this case, Amentum had held a contract with NASA, which contained a minimum ordering requirement for task orders of $8 million in the fiscal year 2015. NASA did initially issue just over $18 million worth in task orders in 2015, only to later deobligate one of those task orders in 2017, which brought the total dollar amount for the task orders issued under that $8 million minimum that was required under the contract. The government argued, upon appeal, the government argued that it did not breach its contract for the 2015 obligation for reason that the deobligation of the specific task order occurred in 2017. So basically the ASBCA didn't buy this argument and held that the task order placed in 2015 remained deducted from the same year it was placed. The NASA couldn't argue that, oh, this task order actually related to costs that were needed in 2017 and didn't fall under that same category, that same minimum that we were supposed to meet back in 2015. Therefore, NASA breached the minimum ordering amount required under the contract. That's all I really have for that one. Structure Projects Incorporated. This is related to COVID-19. The ASBA considered whether a contractor could recover costs arising from the COVID-19 pandemic. Structure, in this case, had been performing a task order involving design and alteration services for an existing medical facility for the U.S. Corps of Engineers in March of 2020. When the pandemic hit, Structure and its subs had to stop work on the construction site for 44 days because the government had limited the base access and contractors not deemed mission essential were not allowed on the base. So the contractor sought schedule and monetary relief, but the government only granted schedule and a schedule extension under its the contract's default clause. So Structure later submitted a claim for additional costs associated with rented equipment that it sat on the project site during the stop work period. Although the government had continued to use the facilities during the stop work period, the government denied the claim on the basis that the base closure was a sovereign act rather than a change. The board found that the sovereign acts doctrine did not apply because COVID restriction did not prevent structure from delivering the equipment for the temporary phasing facilities, which were continued to be utilized by the government during the stop work period. So basically, its services that it provided were still being used during that time. Therefore, structure was entitled to compensation to the extent that the government utilized the facilities during the stop work period. And therefore, the contractor could collect costs for the use of those rented materials.
All right, John, well, thanks for that. And thank you, everybody, for joining us this afternoon. I apologize that we were running a little bit late. I do see that we have one question. Somebody was asking about statistics related to the average duration from filing with the Armed Services Board to a decision. I don't have the best answer for that because every case is different and how it goes, whether we're going through ADR, mediation, potential settlement. But I will say if we are going from an initial filing all the way to a hearing and the issues aren't overly complicated or low value, say we're talking, under $1 million, that would likely take about a year and a half to process through the litigation procedures, get to hearing. And then as far as the decision, I mean, the last decision we were waiting for, it took a year and a half to get a final decision from the board. I'm not so sure that is still the case. As far as getting a decision on average, I would say a year. A year and a half seems a little long, but it really depends on the docket that they're currently working with. And, based off of the amount of cases that were filed last year, and there being a reduction, our armed services may be moving through those rather, quicker than they were. But I would say it's safe to say at least a year for a decision from the date of your hearing. So these cases do not move quickly, to be quite honest. And the Court of Federal Claims, we used to say that, we would recommend you go to the board because they move faster, but that is no longer the case. They tend to move just as slow as the court. So it's just something to keep in mind as far as if you're looking for a speedy resolution, if the value is over, the 50,000, 100,000 that applies to an accelerated procedure at the board, that a decision on these cases can take years. So it's just something to consider moving forward. And then as it relates to any questions on claims, REAs appeals, or really any of these new cases that have come out over the year, or any questions about statistics coming out of either board or the NBAA, you can always reach out to myself or to John. Our information is on this last slide. It's also on our website. So feel free to reach out with any questions. I'm happy to answer any thing that pops up even after the webinar. But again, thank you everybody for attending. We appreciate it.